Welcome back to my channel. Today we're delving into the complex and heartbreaking case of Madeline Soto. Stephan Sterns stands accused of the abuse and tragic murder of 13-year-old Madeline Soto. For those who might not be familiar, Stephan Sterns is the ex-boyfriend of Madeline's mother, Jennifer Soto. Madeline was found a week after her disappearance, and since then, Jennifer has not been seen publicly. Stephan Sterns faces two separate trials related to Madeline, one for the abuse in CSAM and another for her murder. The trial for abuse in CSAM is set to take place this month, while the murder trial is scheduled for September 2025. Despite the gravity of both cases, Stephan's public defender has filed over 60 motions for the murder trial, but only a few for the upcoming abuse and CSAM trial. Among these motions is a request for a continuance. As of now, it remains unclear whether the continuance has been granted, but the pretrial is still on the schedule as originally planned. In this video, we'll be listening to the details of the motion for illegally seizing Stephan Sterns' cell phone and vehicle, and discussing its implications. Your opinions matter, so please leave your thoughts in the comments section below. And if you haven't already, make sure to subscribe to our channel. We have plenty more information and updates to share with you, and you won't want to miss our upcoming videos where we'll be covering this case and exploring new angles. Stay tuned and let's dive into this case together.
Motion to suppress evidence obtained from unlawful seizure of cell phone comes now the defendant, Stephan Michael Sterns, by and through his undersigned counsel, pursuant to the Fourth Amendment to the United States Constitution, Article I, Section 12 of the Florida Constitution, and Florida Rule of Criminal Procedure 3.190 GN. Hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, Introduction. This case presents a flagrant violation of Mr. Sterns' constitutional rights under the Fourth Amendment and Article 1, Section 12 of the Florida Constitution. Detective Tagler with the Orange County Sheriff's Office unilaterally seized Mr. Sterns' cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported consent for its forensic examination. Because this seizure was unlawful, and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Sterns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. Evidence to be suppressed. Any and all tangible or intangible evidence obtained contemporaneous to and following the illegal seizure of Stephan Michael Sterns' cell phone, specifically including, but not limited to, all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. Standing. Stephan Michael Sterns has standing under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and possessor of the cell phone that was illegally seized on February 27, 2024. Riley v. California establishes that cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. Riley v. California. Burden on the moving party. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. Norman v. State. 2. Statement of facts. 1, 2, 3, 4, 5, 6, 7, 8, 9. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. On February 27, 2024, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Sterns. Detective Myra Tagler of the Orange County Sheriff's Office was assigned as lead investigator. On February 27, 2024, at approximately 1,600 hours, Detective Tagler, accompanied by Detective Acosta, contacted Mr. Sterns at his residence. The detective's interactions with Mr. Sterns were audio recorded and captured the exchanges between law enforcement and Mr. Sterns. Mr. Sterns's residence is located at 4012 Santa Maria Drive, Kissimmee, Florida 34746. Detective Tagler sought limited access to Mr. Sterns's cell phone, specifically requesting only to check his Google login status by asking, "Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google." Mr. Sterns responded yet to this specific and limited request. After exceeding the scope of this limited consent, Detective Tagler unilaterally announced, "I am going to hold onto your phone, and I'll give it back to you when we're done." 10. Mr. Sterns expressed explicit concern about maintaining contact with his father through that phone. 11. Detective Tagler dismissed Mr. Sterns's concerns by stating they could call Ms. Soto's phone instead. 3. 12. Mr. Sterns was given no choice regarding the seizure of his phone. 13. No consent was sought for the seizure of the phone. 14. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. 15. The detectives did not present Mr. Sterns with a written consent form for the seizure. 16. The detectives did not advise Mr. Sterns of his right to refuse consent. 17. The detectives did not provide Mr. Sterns with any documentation regarding the seizure of his phone. 18. The detectives did not document any exigent circumstances justifying the warrantless seizure. 19. On February 28, 2024, at approximately 0130 hours, detectives again contacted Mr. Sterns. 20. This second contact occurred approximately 9 hours and 30 minutes after the initial seizure of his phone. 21. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, "I told you that I was going to hold on to it and that we would like to download your phone, right?" 22. The detectives presented Mr. Sterns with an ultimatum. "Is this something that I have your consent to do, or do I need to get a search warrant for your phone?" 23. At the time of this midnight interaction, Mr. Sterns had been detained outside in 50-60 degree temperatures. 24. Mr. Sterns was wearing only flip-flops, khaki pants, and a thin hoodie. 25. Mr. Sterns had not eaten all day prior to the incident. 26. Mr. Sterns was not allowed to return to Ms. Soto's vehicle, which was heated despite the cold weather conditions. 27. Earlier that night, Mr. Sterns had taken Ativan, a prescription medication, to manage his panic attacks. 28. Mr. Sterns clarified to the authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. 29. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. 30. Ativan is known to cause drowsiness, sedation, and impaired alertness. 31. Mr. Sterns described the effects of Ativan to law enforcement, stating, "This is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours." 32. At approximately 0240 hours on February 28, 2024, Mr. Sterns's phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. Legal argument: A. The warrantless seizure of Mr. Sterns's cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property, even when no search has taken place. United States v. Place 4. A seizure of property occurs when there is some meaningful interference with an individual's possessory interests in that property. United States v. Jacobson. The instant matter presents precisely such a meaningful interference, as Detective Tagler unilaterally seized and retained Mr. Sterns's cell phone for over 9 hours without consent or probable cause. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with Fourth Amendment jurisprudence. State v. Hernandez. While law enforcement may temporarily seize property to prevent the destruction of evidence while seeking a warrant, such seizures must be properly limited in scope. The United States Supreme Court has emphasized that courts must consider the length of the detention in determining whether a seizure is reasonable. The Supreme Court held in place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed unreasonable in place. The Florida Supreme Court's analysis in Golphin v. State further illuminates why the seizure here was unconstitutional. Golphin v. State. In Golphin, the court examined whether retention of identification during a brief warrants check constituted a seizure, emphasizing that not all encounters between law enforcement and individual citizens constitute seizures, but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interests. Unlike Golphin, where officers merely retained identification briefly during a consensual encounter, Detective Togler effected a full seizure by unilaterally announcing she was taking possession of the phone without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Sterns of his ability to communicate with family members. The extended duration and complete deprivation of Mr. Sterns's possessory interest in his phone demonstrates why this case falls squarely within places holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tagler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure. Instead, Detective Tagler retained the phone for over 9 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length of the detention alone precludes any argument that this was a properly limited investigative detention under place and its progeny. 1. The initial seizure exceeded the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirement, such consent is strictly circumscribed by its express scope and circumstances. Florida v. Gemino. The United States Supreme Court has established that the standard for measuring scope of consent is one of objective reasonableness. Specifically, what would the typical reasonable person have understood by the exchange between the officer and the suspect? This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permission granted for one limited purpose cannot justify broader government intrusion. In Apelt v. State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. Similarly, in State v. Wells, the Florida Supreme Court determined that consent to search a car trunk did not extend to closed containers within that trunk. State v. Wells. These decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. 7. In the instant case, Mr. Sterns provided extremely limited consent for Detective Tagler to go in your settings real quick solely to see if you're logged onto your Google. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of the device. Detective Tagler's unilateral announcement that she was going to hold onto your phone and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Sterns's limited consent. This expansion of authority mirrors the impermissible scope extensions rejected in both Apelt and Wells. Just as consent to look in a trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis and place that even brief investigative detentions of personal property must be strictly limited in scope and duration. When Detective Tagler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed, rendering the extended seizure unconstitutional under both consent and general Fourth Amendment principles. 2. No exigent circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when exigent circumstances exist, such circumstances are few in number and carefully delineated. Welsh v. Wisconsin. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because the exigencies of the situation made that course imperative. Coolidge v. New Hampshire. None of the recognized exigent circumstances existed here. First, there was no hot pursuit of a fleeing suspect that would justify the warrantless seizure. See United States v. Santana. Mr. Sterns was at his residence and fully cooperative with law enforcement when Detective Tagler seized his phone. He made no attempt to flee or evade the officers. Second, there was no imminent destruction of evidence. Detective Tagler articulated no specific facts suggesting Mr. Sterns was attempting to, or about to, delete data from his phone. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. The mere possibility that additional digital evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. Riley v. California, where, as here any purported destruction of evidence had already occurred, law enforcement cannot justify a warrantless seizure based on preventing what has already happened. Third, no emergency aid circumstances existed. See Brigham City v. Stewart. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. See Brigham City v. Stewart. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable basis to believe that an emergency exists requiring immediate action to prevent imminent harm. Missouri v. McNeely. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2,000 hours on February 26, yet Detective Tagler did not seize the phone until 1,600 hours on February 27, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was imperative. See Mincy v. Arizona. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Even assuming arguendo that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession. The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. State v. Fultz. Detective Tagler's own statements revealed the investigatory purpose behind the seizure, as she explicitly told Mr. Sterns, "I told you that I was going to hold on to it and that we would like to download your phone, right?" Demonstrating from the outset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured, any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tagler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Instead, law enforcement simply held it for over 9 hours before seeking consent for a forensic examination. This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within United States v. Moss. This objectively reasonable belief must be based on specific articulable facts and reasonable inferences that could have been drawn therefrom. Citing Terry v. Ohio. Here, Detective Tagler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief in an emergency requiring immediate warrantless seizure of the phone. Fourth, there were no community caretaking circumstances requiring immediate action. See Katie v. Dombrowski. The phone itself posed no danger to the public, and its seizure was clearly investigatory, rather than for community protection purposes. Fifth, there were no exigent circumstances related to officer safety. See Maryland v. Bowie. The phone posed no threat to officer safety, and Mr. Sterns displayed no aggressive or threatening behavior that would justify its immediate seizure. Instead of demonstrating any recognized exigency, the record shows that Detective Tagler had ample time and opportunity to obtain a warrant through the Ninth Circuit's established emergency duty judge system under Administrative Order 0784-11, which has maintained a 24/7 emergency duty judge protocol for nearly 40 years specifically to handle after-hours warrants. The United States Supreme Court has emphasized that the availability of telephonic warrants is relevant to the exigency analysis. See Missouri v. McNeely. Here, Detective Tagler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Sterns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly egregious and negates any claim of exigent circumstances. Despite the well-established warrant system and the availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this resource, further demonstrating the unconstitutional nature of their actions. 3. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activity, such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. Citing Bailey v. State, the consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action. The fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. Wong Sun v. United States. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by means sufficiently distinguishable to be purged of the primary taint. The Florida Supreme Court has consistently held that evidence discovered by exploiting previous illegal conduct is inadmissible. Craig v. State. Here, there was no break in the chain of illegality between the unconstitutional seizure and the subsequent searches of the phone. The extended deprivation of Mr. Sterns's phone created coercive circumstances that led to the midnight consent for its forensic examination. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree. Conclusion. Detective Tagler's warrantless seizure of Mr. Sterns's cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communication device, without consent or exigent circumstances, violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. Wherefore, the defendant respectfully requests this honorable court, 1. Set this matter for an evidentiary hearing pursuant to Flaw. R. Crim. P. 3.190, H. 3. 2. Suppress all evidence obtained from and derived through the unlawful seizure of his cell phone, and 3. Grant such other relief as this court deems just and proper. Respectfully submitted, Melissa Vickers.